Ladies and gentlemen, welcome back to my YouTube channel. My name is Kathy. We previously went over the fact that Mr. Kohberger has filed a Franks motion seeking a Franks hearing. This was filed on the 14th of November 2024. It stated that Mr. Kohberger was seeking a hearing on the motion. It also stated that the proffer, that is the evidence that Mr. Kohberger is presenting, that he feels entitles him to such a hearing, was being submitted under seal, and that there had been a stipulation between the state of Idaho and Mr. Kohberger that the documents should be filed under seal. That's away from the public realm. This does not mean at all that the state agrees that there's been any wrongdoing here, just that the state is joining Mr. Kohberger in agreeing that the documents relative to whether or not he's entitled first to a hearing is proper. Those things are what that agreement relates to, must be under seal. I expect that the state will file a very strenuous response opposing Mr. Kohberger's position that any law enforcement official violated his constitutionally protected rights under the Fourth Amendment against illegal searches and seizures and the state constitution for the same thing. That response is due the beginning of December per the court's order of October 9th, 2024, the pretrial order. But first, what is a Franks hearing? Well, that is a proceeding that is established pursuant to a United States Supreme Court ruling from 1978. It is entitled Franks versus Delaware. And if you'd like to find it in the U.S. Reporter, look it up, 438 U.S. 154. That's the page where it starts, 1978. Now, let's go into some of the details about what Mr. Kohberger's burden of proof is here. Well, first, what is a Franks motion and hearing? It's a legal proceeding in criminal cases, not civil. This only deals with criminal cases, where a defendant tries to say that a warrant is being challenging the truth of the information that was used to support it that led to the issuance of warrants by a judge at an ex parte proceeding. You know, in this case, all of the warrants dating back to the warrant finding probable cause that was signed by Magistrate Judge Marshall back on December 29th, 2022, was done one-sided. That's how these things happen. You don't have defense there to argue against what the state attorney, Mr. Thompson, brought forward in the complaint to Judge Marshall. It is only the state that's there. So this Franks hearing in motion is the first time that a defendant would have an opportunity to come back and say, you know, what happened in the past that led to these warrants, they are improper under the Franks ruling. They are improper under the Fourth Amendment to the United States Constitution and the Idaho Constitution, saying that a warrant should only be issued if there's a finding of probable cause, and it must be truthful. The information in that warrant must be truthful. So this is what the defense is asking for. A Franks motion, which they filed on the 14th, is the legal document that's presented to the judge that sets forth Mr. Kohberger's request for a Franks hearing and the specific challenges that Mr. Kohberger is raising. Now, this type of hearing is always done after the fact. This is after a search and seizure has already taken place. If Mr. Kohberger is successful at the hearing, then the judge will likely throw out or suppress, meaning they're going to keep it from coming before the jury, all of the evidence, or some of it, that was seized under the warrant that Mr. Kohberger would have to convince Judge Hippler was improper. Now, the Fourth Amendment of the United States Constitution says that the search warrants that we have seen in this case, a lot of them are heavily redacted, they're under seal. But going back to the affidavit of probable cause, the search warrants that led to Mr. Kohberger's arrest, the search warrants that allowed law enforcement to go into his parents' home in Pennsylvania, seize him, seize his car, thinking that this was suspect vehicle 1, enter the property, take things from the property, go to his apartment in Washington, take things there, go to AT&T, go to get phone records, to get a trap and trace. Those all required warrants. So the Frank's motion that's now filed is a legal document that's given to the judge and that sets forth its request and stating that after the search and seizure already happened, where evidence was taken, that these warrants or warrant, if it's just one, were improper. So what the defendant has to do is challenge the truth of the information that tried to establish probable cause at the ex parte proceeding that led to the issuance of the search warrant. Now, what are some of the things that might be stated? It might be said that a search warrant contained a false statement or misstatement of the facts, or contained false information or material information that was false, or that it was made with reckless disregard for the truth, or contained deliberately misleading information or omitted information that the judge who's looking at this application for a search warrant is relying on. Remember when Bill Thompson went to Magistrate Judge Megan E. Marshall, she's not going out and looking at the actual evidence that law enforcement said it had. She is relying on the affidavit that was submitted by Brett Payne. So let's just say that that is the affidavit that Mr. Kohberger is challenging, and we don't know because all of this is under seal. I am simply using this as an example. Mr. Kohberger may say that there was deliberate intent to keep information out, and it was knowing that the warrant was issued on an affidavit that contained false information under penalty of perjury, or with reckless indifference, a really high standard of negligence. Now, we've seen in some of the documents already filed that what they're saying is that exculpatory evidence was kept out. What is exculpatory evidence? That is evidence that would tend to prove that Mr. Kohberger was not the person who is the sole and correct defendant, as Moscow Police Department alleged, that committed the atrocities at 1122 King Road. Inculpatory evidence is the exact opposite. That's evidence that would tend to show that he was. So we've seen information already that what they're saying is exculpatory evidence was kept out of these warrants. They also said the same when they were challenging the grand jury proceedings and the indictment, that based on after the fact, because again, Mr. Kohberger is not able to be in the room, his defense attorney's not there, this is strictly the state attorney's show, where the prosecutor goes in and makes a presentation and proffer to the grand jury. Jay Logston, I believe it was, is the one who stood up in open court and said that exculpatory evidence was kept from the grand jury. So these are the things that Mr. Kohberger will need to convince Judge Hippler of even before there's any ruling, just to even get to that hearing. That hearing, if granted, will be in chambers. It's going to be an evidentiary hearing where people will come forward, be sworn under oath. We can venture a almost 100% wager that it's going to be members of law enforcement that will be now examined by defense counsel and then subject to any examination by the state attorney. The court could also have questions. So that's an evidentiary hearing, and that will 100% be behind closed doors. And then Judge Hippler would render a ruling, if and only if he grants that hearing. If he finds that there was impropriety to the level that it violated Mr. Kohberger's constitutional rights, the evidence could be suppressed. That means that any of the evidence that came from those warrants could be kept entirely from the jury, or it could be thrown out altogether. Either one of those results would suffer a devastating blow to the prosecution if that happens. And we're not saying that there's going to be a successful result. We're just saying that this is what his burden of proof is. Now, the next event that we need to look forward to in the docket is when the state files its response. That is due, per the court's order of October 9th, by early December. And then the defense would have an opportunity to file a reply going toward anything they feel is misleading or inaccurate or wrong in the state's response. And then Judge Hippler would make a ruling. That's what I believe will be the next few steps here. I want to thank you very much for joining us here today at the YouTube channel on this very, very important and rather unusual motion. You don't see Frank's motions filed all that often. If you have any comments, please provide them below. Like, subscribe, share. And I want to thank you for your support.